Any mention?
My Lord, with your permission, if I can mention item 12 of Lordship's daily list. My Lord, if this matter could kindly be taken up after the puja break, I need some time to prepare for this matter.
You're for the
Respondent 3, my Lord.
for what?
No objection.
On premier by Mr. Estendal, then counsel for the respondent number 3, seeking accommodation on grounds of personal difficulty. Matter not being the same not being objected to by Ms. Letter counsel of the petitioner. Matter is adjourned. This is after 2 weeks.
Obliged.
May please, Your Lordship. Lordship, I beg to make a mention of item 14. Item 14. So I pray this matter to be adjourned for today. Can you have it after vacation, Your Lordship?
Why? After 3 weeks, then Your Lordship.
3 weeks. Can you have it after vacation?
Why?
Some difficulties there, Your Lordship.
On premier by the petitioner, this is matter after 3 weeks.
Apply, Your Lordship.
Lordship.
Lord, I beg to mention item number 7 and for respondent number 3 and 4. If this matter may be taken up after vacation, my Lord.
No objection, Your Lordship.
On premier by Ms. Letter counsel of the respondent number
3 and 4, my Lord.
3 and 4. 1. The same not be objected to by Ms. Letter counsel for the petitioner. That is adjourned. This is after 3 weeks.
Obliged, Lordship.
May it please, Your Lordship. Lordship, I beg to make a mention of item 11. Lordship, in this matter, Your Lordship, the petitioner has filed an application for amendment of the. In this matter, Your Lordship, the petitioner has filed an application for amendment of the petition, Your Lordship. So I'm.
They yet to file the objection to the amendment application, Your Lordship.
Okay. Have you filed?
No,
Your
Your Lordship.
Lordship.
I'm seeking some accommodation, Your Lordship, to file the objection.
You are paying for who?
Respondent 4 to 8. I'm
what
for
is
the
this
college,
matter
Your
about?
Lordship.
Lordship, this is with regard to the appointment, Your Lordship.
Appointment?
Teachers, Your Lordship.
Cool.
My Lord,
Shillong
it
College.
pertains to Shillong College. I have been appointed respondent 9. They are challenging my appointment.
Okay. Then
I'm
who are
preparing
you?
for the college, Your Lordship.
Okay. Managing committee? Or what do we call it? Governing body?
Governing body.
On pre-made by Mr. Letter Counsel for the respondent and governing body?
428, Your Lordship. 428.
428. Seeking accommodation. The same not be objected to by Ms. Letter Counsel for the petitioner. Matter is adjourned. This is after 3 weeks.
May it please, Your Lordship, I beg to mention item number 5, Your Lordship, on behalf of Mr. Almajal. Lordship, may this matter be fixed after 2 weeks, Your Lordship. Number 5.
Pre-made with the appellant. This is matter after 3 weeks.
W.
Highly obliged, Your Lordship.
May it please, Your Lordship. I beg to mention item number 15, Your Lordship. Senior Conducting Counsel is on leave, so we are praying for 3 weeks' time, Your Lordship.
Can be taken up after the puja vacations.
Pre-made by the petitioner. This is matter after 3 weeks.
Similar prayer, Your Lordship, for item number 13. 13, Your Lordship.
No objection. Mention has already been made. That has already been adjourned.
13.
13.
Not, Your Lordship. 13.
Yes, 13. Somebody has mentioned. This one. Okay. So 13 up to pass on 3 weeks.
Much obliged, Your Lordship.
Back to mention item number 10. This this appeal was heard by the learned Justice Bhattacharjee, my lord, and I had concluded my argument. The cause list shows that it is placed before your lordship now, my lord. So I think I have to argue again, my lord. So if it can be, if it can come after pujas, my lord.
No objections, my lord.
You are there?
Yes, my lord.
On previous by Mr. M. Sharwal, the lead counsel, that is adjourned. This is after 3 weeks.
In fact, I was supposed to file my bullet points today, my lord. We'll take it out.
Things have happened, so we'll have to.
We have to, my lord.
Argue.
Oblige, my lord.
Oblige, my lord.
On supplementary list, item number 1.
Lord, there's a delay of 205 days in filing the appeal. So notice may be issued.
Mr. Liman Longbri, learned counsel for the applicant, has submitted that the applicant has filed an appeal against the order, common judgment and order dated 3/3/2025, passed by the learned member MSCT Tura, West Garo Hills District, in MSCT case number 1 of 2024. However, while preferring the said appeal, a delay of 205 days has occurred, which an application for condonation of the same has been filed for this court. At this juncture, it is submitted that notice may be allowed to be issued from the respondents. Therefore, let the notice be issued, returnable within, the same returnable within 2 weeks. This is the matter thereafter. Deeply.
Item number 2.
These 3 are connected matters, my lord, 2, 3 and 4. In fact, for number 4, item number 4, my lord, which is criminal appeal number 63, miscellaneous application number 100, which is an application for suspension of sentence, my lord. My instructions were that, my lord, the convict is suffering from some serious ailment. He was having these seizures and all that. So, my lord, the court had requested for a medical report, my lord. So, I believe the medical report has been submitted, my lord, today.
In item number.
No, what about you're making submission item number?
Item number 4 today, my lord, because
what about 1, 2, 3? I mean,
2, 3, 2, 3, 4, your lordship.
They are all connected matters, my lord, arising out of the same order of conviction and sentence, my lord.
As far as 2 and 3 are concerned?
2 and 3 are concerned, my lord. In fact, my lord, all 3 are aged 70, almost 70 years. Look, this FIR was filed in the year 1997, my lord. Charge sheet was filed in 1997. Trial took more than 28 years. So by the time the court came to a finding and convicted them for a period of 5 years, all 3 are 70 years old. Well, I have also filed in the appeal is within time. I have only filed a miscellaneous application for suspension of sentence. Now, my lord, when I moved the application, I was categorically told that this particular person in criminal appeal number 63 is suffering. But for the others also as well, my lord, the fact is, my lord, when a fixed amount number of sentences passed, my lord, the court can liberally grant bail and suspend the sentence. Well, actually what happened, my lord, this matter came up in the supplementary cause list last night. So, my lord, I could not get a time to actually prepare. My lord, since, my lord, the medical report is here, if there is anything in the medical report, then, my lord, may peruse the medical report as far as item number 4 is concerned and pass appropriate orders. Otherwise, my lord, for all 3, in fact, my lord, when these people are more than 70 years old, all of them will be suffering naturally from some ailment or the other. So, my lord.
But even so, see,
my
as
lord.
far as, you know,
Lordship.
ailment is concerned,
my lord.
We have competent doctors in the prison. We have a clinic.
But
in fact,
yes.
in fact, I will tell you that during our inspection,
my lord,
we have found that the clinic This is Shillong case.
This is Joy, my lord. Joy.
Anyway, we found that clinic more often than not are well maintained. They have their doctors ever present. Beds are always clean. Medicine available.
My lord.
So there's no question of
only my lord, two links of my submission, my lord. Application for suspension of sentence, my lord. Court can take into consideration two things, my lord. One is on merit as well.
Oh, that of course.
My lord. So, on merit, my lord, the case is such that, my lord, these people were arrested. Within 24 hours, their confessional statement was recorded. Conviction is on the basis of confessional statement only. So, on merits also, I do have a case to argue. So, my lord, since if we can have it right after pujas, my lord, all these three, my lord. Okay. Thereafter, lordship, after hearing me pass necessary orders, all three.
You have brought the
lordship. Whether lordship would like to see the medical.
I'll keep it on record.
Lordship. Nothing. Lordship, that is in the next page, Lordship.
Where's the reference to this?
Item number 4, miscase is 100. Miscase number 100, my lord.
On pre-made by Mr. K.C. Gautam, counsel for the petitioner. This matter to be taken up after 3 weeks.
If Lordship call the trial court record and make a purpose, the matter
Records have already been called.
Then the matter can be heard finally, Your Lordship.
I'll just make an endeavor, my lord.
No, then in that case, you see, trial court's record have come.
My lord.
Then you file your paper book.
Yes.
I will try to, well, I'll make an endeavor.
Whatever the case may be, an order will be passed for you to prepare the paper book.
Yes, yes, my lord. We'll start.
Pursuant to this court's previous order dated 12/9/2025, the record from the trials court the records from the trial court have since been received by the registry. Accordingly, on pre-mail, the appellant is allowed to prepare the paper book. As prayed for, this is not after 3 weeks.
Oblige, Your Lord.
Much obliged.
Item number 5.
Yes.
My lord. My lord, this is the second bail application, my lord, pertaining to Nongpa Women PS case number 7210 of 2024 under section 7, 8, 9M, 10, 11, 3, 12 POCSO Act, my lord. This is second bail application before this court. So, my lord, an FIR was lodged, my lord, which is at page 47. That is the type copy. 48 is the original copy, my lord. For the sake of convenience, I'll read the type copy, my lord, which is at page 47. If I may read, my lord.
Yes.
With reference to the subject cited above, I have the honor to inform you that my daughter, Miss So-and-so, aged 9 years, have been molested by Shri So-and-so at his residence on 27th October 2024. As me and my husband, we went to visit the sick person, Shri So-and-so at Laban, Shillong on 27th October 2025. That means about a month ago. I sent my daughter to their house for care as a neighbor. They always being helpful, especially his wife. She care my daughter as her own. So with this faith, I sent my daughter with her on that day. I came to know about this when my husband on 25th November, subsequently after 1 month, my lord, 2024, forgot the mobile phone at home. When he reached home in the evening, he checked the phone. He came to know that on the Google Chrome, somebody searched for adult video. When he asked about it, the daughter told that Sri so-and-so, the accused person here, my lord, show her this video. When I do the detailed inquiry, she confessed that he had touched her chest, private part, and also he told her to sleep with him. So this is the allegation, my lord. So thereafter, my lord, subsequently, a case was registered, my lord, and thereafter, my lord, the 161 statement as well as, my lord, 164 statement, a medical was done, my lord. So a charge sheet was filed, my lord. Charge sheet was filed.
My lord, we are filing the affidavit today.
You have not filed?
No, today we are filing. Actually, we already filed today. It's in the registry.
You have filed?
Yeah, we have filed
You
today.
receive copy?
Oh, Your Lordship, I have been supplied with a copy.
So,
Oh,
are you filing any rejoinder?
Lordship will have to seek some instructions.
Mr. P. Doctorate, learned counsel for the respondent 4 to 6 have submitted that the affidavit in opposition on behalf of the said respondents have been filed today. Mr. learned counsel for the appellant has submitted that, for the petitioner has submitted that he has that the petitioner has received copy of the said affidavit in opposition. However, the learned counsel has sought for time to seek instruction as to whether any rejoinder is to be filed or not. Have you filed your counter?
I'm appearing on behalf of respondent 1, 2 and
Yes,
3.
that's what I'm asking. Have you filed your counter?
No,
You are filing or not filing?
As per I remember, Your Lordship, in the last, in many last occasion, the senior learned counsel said that he won't file the affidavit.
Not file.
Yeah, he said he will not file the affidavit.
This learned counsel appears for respondent 1 to 3. As prayed for, this matter up to 3 weeks.
Your Lordship, the interim order may be extended.
Is
as
there
well.
an interim?
Yes, Your Lordship.
Interim order pass will continue to be enforced until further orders.
Much obliged, Your Lordship.
Item number 2.
Yes.
Please, Your Lordship. Your Lordship, item 2, 3, and 4. In item 2, Your Lordship, we have filed the compounding application. It's still been pending before the original director. As far as in item number 2 and 3, Your Lordship, I would like to place the resolution passed by the Board of Directors in item number 2 and 3 and 4. My learned friend is there, Your Lordship. Your Lordship, this is in Manipur. This is the resolution adopted by the board yesterday that they will file all the compounding applications right from 2014-15 up to 23-24. So to have such kind of a resolution also, Your Lordship, took a lot of time to have this board meeting. All these matters should be compounded and appropriate applications of compounding be filed before the competent authorities, that is the regional director. So I humbly pray, Lordship, that in another
that has not been done.
No, Your Lordship, because in few there were approval for 1-2 years. So now finally they have taken the resolution that from 14 onwards till 2024, they will compound all the whatever the errors that has happened. So now I will not take time, Your Lordship. They have already appointed a company secretary also to file the appropriate applications before the regional director.
Okay.
So I pray that maybe in 4 weeks' time, all the applications will be filed, and and Your Lordship, then I'll apprise this court what is the situation before the regional director.
Yes, Mr.
Yes, Your Lordship.
But what about the first case?
First case, Your Lordship, it is on the process.
First case, Your Lordship, the regional director has been sleeping over it. I don't know why. We've been following it up.
This regional director, a new regional director is Jan. He'll be joining on next Monday.
You've been saying that, for how many months?
It will take within 1 month. Whichever file it is within months. They will fix the date and hearing took place and after that.
During pendency of the case, I not mistaken, around 2, 3, 4, 5 regional directors were appointed.
But this is something has to be done.
It will be done.
At this
And
steps,
Mr. Denmark can accordingly apprise the regional director to pass necessary
This
orders in those pending.
last occasion also this you visit last Saturday. This I call this ROC. He came and he tell that it will be done. So not only this other matter also.
whatever the case may be, but he cannot just delay the matter. It relates to, I have said time and again, it relates to a pending proceeding in court. This court, on the prayer of the parties, has been lenient enough to allow. Otherwise, the matter can be heard finally and then disposed of on merits.
This matter will be disposed of at the earliest.
I think the last chance will be given to you. Please, you convey your or you advise your client accordingly.
Item 2, Amrit Simmons.
Item 2, Mr. Pinongri, counsel for the petitioner, has submitted that the relevant application for compounding of the offences have been filed before the regional director. Regional director what?
Northeastern region.
Registered company Northeastern region. Regional director registered company Northeastern region.
Regional director?
Northeastern region.
Northeastern region. As required, empowered under the Companies Act, Indian Companies Act or Companies Act?
Yes, Your Lordship, Companies Act.
Empowered under the Companies Act to take up such matters for consideration. However, till date, the matter has not yet been taken up by the said regional director. It is Mr. R. Devnath, counsel for the respondent, has submitted that due to the fact that from time to time the regional director have been transferred and a new incumbent has occupied the position. Therefore, the said matter could not be taken up in earnest. It is prayed that some more time may be allowed for the application of the petitioner to be taken up by the regional director. This court, on consideration of the submission made, would remind the parties that on this ground alone, matter has been adjourned from time to time. It is incumbent on all concerned to ensure that closure is made as far as the dispute in this petition, as far as the dispute pointed out in this petition is concerned. Accordingly, the respondent is allowed some more time for the matter to be heard and to to be decided and a report to be filed for this court accordingly. This matter after 4 weeks. It will be better?
So it will be 6 weeks, I think, maybe better. In between some puja holidays also, the 6 weeks.
So 6 weeks. There were 3, 4. Mr. Pinobri, our counsel petitioner, has produced copies of the proceedings of a board meeting of the petitioner company, wherein it was resolved that the company would make appropriate application before the
Regional director.
Regional director. As
Not
far
Eastern
as,
region.
Regional director, not Eastern region. As far as the issue of compounding of the offences relating to the year 2014 to 2020-24 are concerned. In this connection, it is prayed that some more time may be allowed for the process to be initiated and to be disposed of by the regional director. Accordingly, as prayed for, the same is allowed. List this matter after 6 weeks.
Obliged.
Item number 6.
Anything?
It's part heard actually.
Yes, I'll do it.
Okay, sir.
Yes.
Actually, I concluded. Anyway, my lord, this matter was part heard before, my lord, not before this bench, my lord. So we'll have to go afresh, my lord. My lord, this is a case, my lord, of my case, my lord. I was superseded by my junior, my lord. My junior, the service matter, my lord. Now, before I come into the law points, my lord, I'll come to the factual aspects, my lord. And this is the 4th round of litigation, my lord. Not confined to this, my lord, issue. What had happened, my lord?
Yes.
My lord, on 19/12/2001,
yes,
I was appointed as constable in the BSF. Appointed constable, BSF. Thereafter, my lord, some vacancy arose to the post of head constable, my lord. Same department. So, my lord, as a departmental candidate, I appeared in the exam. I came out successfully, my lord. So, thereafter, I received an appointment letter as head constable, my lord. So, my initial place of appointment was Manipur. So, my new place of posting as head constable was Taliguri, Siliguri, West Bengal, my lord. So, my lord, that was in the on 29/11/2011, my lord. So, after I reached Taliguri, Siliguri, West Bengal, my lord, I waited for 6 months, but my new my new post, my lord, was never handed over to me. So I waited for 6 months. Surprisingly, on my query, my lord, after 6 months, my lord, a medical examination was conducted on me, and I was found to be HIV positive, my lord. Now, because of My status is HIV positive, my lord. My shape, SHAPA, my lord. Understand? My shape was, my lord, brought down to shape 2 from shape 1, my lord. And because I have been, this is, my lord, that simply because my status is HIV. So I was brought to shape 2. Now, my lord, there are two categories of, my lord, personnel in BSF. One is the ministerial, the other is the combatized one, my lord. So I am in the ministerial, my lord. Meaning thereby, my lord, I am not in the combatized, my lord, category where I have to go to altitude and, my lord, high altitudes and carry on, my lord, weapon. It is not so. It's a clerical, my lord, job. So I was denied my promotion, my lord. There, I was advised to go back to my parent department and join as constable. So I challenged that in the first round of litigation, my lord. The judgment is that, my lord, my lord. So what had happened in the first round of litigation, my lord? The BSF department was instructed to forthwith promote me, and subsequently, my lord, what had happened? I was promoted in view of the, my lord, instruction of the Honorable High Court, my lord. I was promoted as head constable. But there again, my lord, when I was promoted, my lord, my seniority was calculated from the date when I was being considered for promotion as per the direction of the High Court. Meaning thereby, my lord, my batchmates who were promoted, my lord, at a previous date, my lord, they became senior to me. So again, the second round of litigation, my lord, I challenged that. And again, an order was passed by the Honorable Court to count my seniority from the day when I had first cleared my exam and an appointment was given to me, my lord. Now the present issue, my lord, before your lordship is that during the course, my lord, there were some vacancy for the post of assistant sub-inspector, my lord. Surprisingly, my lord, the department, the respondent, my lord, they promoted my batchmates and I was left out, my lord. I was left out. So I have challenged that here. And the sole ground they have taken in their affidavit, my lord, is that because of my HIV status, my lord, my shape has been brought down from shape 1 to shape 2. And therefore, I am not entitled for, my lord, promotion, my lord. Now, one thing is very important to note here, my lord. Even in the earlier round of litigation, my lord, when I was denied the post of head constable, my status was also HIV positive and I was brought down to shape 2. In spite of that, my lord, the Honorable Single Judge, my lord, directed the respondent to give me my promotion, my lord. And that was never challenged, my lord. Therefore, that I am entitled for promotion even if it is taken for the moment that my shape is 2, my lord. So that has never been agitated before your lordship, my lord. Now, in this regard, my lord, the Honorable Supreme Court as well as several high courts of the country, my lord, has taken a similar view that a person cannot be discriminated, my lord, in case of appointments, jobs, promotions. They cannot be discriminated, my lord. Not at all. Now, kindly, my lord, I made a gist of, my lord, this. Here. One more. and give her. Here, my lord. Number 1, my lord, violation of HIV/AIDS Prevention and Control Act 2017. This is an act, my lord.
Where's the first show this called the impugn order?
Chairman. As to the order of my lord, denial.
Whatever you have assailed in this petition.
Yes, my lord.
That is your consideration for promotion to assistant sub inspector.
Yes, my lord. There is no speaking order, but there is a list of seniority at page 25, my lord.
Oh, see, Mr. Guru. First, you have to point out, as you have submitted earlier, there are vacancy in the position of assistant sub inspector. How those vacancies are to be filled up, whether by direct recruitment or by promotion.
By promotion.
What is the percentage, and if by promotion, what is the procedure to be followed?
My lord.
Whether that was followed in the case of others and not allowed as far as you are concerned, whether you have to apply, all those things have to be,
exactly, my lord,
spelled out.
My lord. Now, my lord, to answer that query, my lord, page 25, my lord. This is a seniority list of 18th October 2012, man.
Yes.
Now my name is placed at 1922 on the first page, 25.
Yes.
And one of my batchmate, my lord, is placed at page 26, my lord. Serial number 1953, Amit Prasad. Meaning thereby I am senior to him, my lord. Now kindly come to page, my lord, 29. This is a seniority list of 2016, as reflected in the, my lord, bottom.
This page 25 is 2016.
Page 25 is 2012, my lord. Page 25 is 2005. It is my lord, reflected at the bottom base.
Oh, you go to the latest one.
I'll come to that, my lord. I just want to point out this, my lord.
Okay.
Now the subsequent seniority list of November 2016, my lord. The same Amit Prasad, my lord, has been placed ahead of me, my lord. Page 29. Serial 954.
Yes.
Whereas my name has been placed, kindly come to Lordship, page 35. 1415. Page 35.
1415.
1415, my lord.
Yes.
So meaning thereby, my lord, in the seniority list of 2012, I am senior to my batchmate Amit Prasad, Amit Kumar,
yes.
And subsequently in 2016, I have been placed below him, my lord. Now this seniority list is, my lord, prepared for the purpose of, my lord, promotion. So the present is...
This page 29 is 2012.
My lord, I'm...
Is it
2016, my lord? Kindly turn to page 30, my lord. Lordship will find it. 2016. At the base, my lord. Base, my lord.
2000? Oh. Good.
2016, my lord.
What is this? See, DOA, this column, DOA seniority 24, see, 24/3/2012, 27/4/2012. Date of appointment.
Date of appointment, my lord.
Yours is serial number.
My lord, in 2016, my serial number, 2016, my serial number is at 1415, page 35. Whereas Amit Prasad, who was junior to me in 2012 seniority list, has been placed ahead of me. Now the present position is that, my lord, this Amit Prasad and others, they are already promoted to the post of assistant sub-inspector, which is not denied by the respondents herein, my lord. So now, my lord, if the affidavit of the respondent authority is perused, it will be found, my lord, it will be noticed that the sole ground on which my promotion has been withheld is simply because of my HIV status. That is the only this thing, my lord.
But has it been reflected in the official records?
No, my lord. But they have brought it in their affidavit, my lord.
Oh, in affidavit.
Yes. So, my lord, the hearing may not conclude today, but just to refresh the memory of the court, my lord. Now, my lord, the act itself says that I cannot be discriminated. The act is, my lord, HIV and AIDS Prevention and Control Act 2017, my lord. This act says, my lord, the denial of promotion is a direct violation of this act, which explicitly prohibits discrimination against a protected person, an individual with HIV, in employment or occupation. The act forbids denying a person a job or an opportunity for promotion solely on the basis of their HIV status, unless it can be proven that they pose a significant risk of transmission or are medically unfit to perform their duties, which is not the case here. So, my lord, here, till date, my lord, I am still discharging my duties, my lord. So, therefore, they cannot say I am unfit. And, my lord, unfit, I can be categorized as unfit unless and until my shape come to shape 5, my lord. So, I am, even if it is, my lord, we presume that my shape is 2, my lord, still, my lord, they cannot, my lord, discriminate me. That is the thing, my lord. The Supreme Court, as well as, my lord, the other high courts has taken similar views, my lord. I have given a gist of that, my lord. Now kindly come to, my lord, page 2.
See, Mr. Gurung, again I keep asking you. You show me all these seniority lists and whatever, but you have not shown me the order, relevant order or communication wherein your juniors have been promoted and you have not been promoted.
Yes, my lord. So far, my lord, the promotion of my juniors, that is, I don't have my lord, the order on that, but that fact is not disputed.
Oh, that is,
they have
for your own weakness, you cannot depend on others. You have to stand on your own.
That is there.
Facts. See, you are presenting your own case. You have to convince the court in what manner you have been discriminated.
Then in that case, my lord, I may be given some time. I'll obtain a copy, my lord. I'll obtain a copy.
You have to. You see, you know. I don't have to tell you, but you know very well.
I understand, I understand,
how to present.
Just that I presume that since it was not disputed, and
it cannot be,
my lord. In that case, my lord, I'll obtain a copy, my lord.
Heard Mr. Argun, Direct Counsel of the petitioner, who has not concluded his argument and has prayed that the same may be allowed to be continued on the next date. Accordingly, as prayed for, this is matter to 3 weeks.
Deputy.
Item number 8.
Me, please, Your Lordship. Lordship, my senior is still on legs, Your Lordship, before court too. So, Lordship, however, Your Lordship, a coordinate bench of this honourable court, Your Lordship, has decided a similar issue, Lordship. So I may be granted sometimes, Your Lordship, to place the decision, Your Lordship.
So 3 weeks.
Lordship.
Prepared by Mr. Learned Counsel of the respondent seeking accommodation. That is adjourned. Necessary of the 3 weeks.
Item number 9.
My Lord, this matter is a cover case. Denial of 7-pay commission benefits. Earlier round of litigation, my Lord, they have been denied 6-pay commission benefits. Therefore, these people, employees, filed a writ petition before the erstwhile Guwahati High Court. Then a single bench dismissed the writ petition that writ petition is not maintainable against the school run by the society, Assam Public School, Light Court. Matter traveled to Division Bench. Supreme Court entertained the writ petition, saying this writ is maintainable, and directed the School Management Authority to pay the 6-pay commission. The management and the Union of India traveled to Supreme Court. Supreme Court dismissed the SLP. They filed a reviews or dismissed. Contempt petition was filed. Subsequently, they came forward and said, we are going to implement the direction of the High Court. So they came back and they implemented the order, pay all the benefits. Now, a few months later, they said they attempted to shut down the school, saying that we have paid all the money we have. Now we don't have money to run, so we want to shut down. So these people are compelled to come before this honorable court.
This is ARPS?
ARPS matter.
Okay.
ARPS matter. And this honorable court took the matter very seriously, that you allow yourself to accumulate the benefits throughout the years. And when the employee is entitled, pursuant to the court direction, you want to shut down the school. This cannot be done. So there was a negotiation, and some benefits also given up by the writ petitioners for the strengthening of the health of the financial position of the school. Later on, they also filed the affidavit that yes, with regard to service condition of these employees, we cannot change because that was already decided by the High Court and upheld by the Supreme Court. Thereafter, my Lord, the 7-pay commission report came, and we requested them to please kindly give us a 7-pay commission report. They are not attending to. Therefore, we filed the petition again. So it is in fact the legal issue whether the employees of the school entitled benefits or not. That is already settled issue. Now they filed the affidavit. They raised the question of maintainability. With regard to maintainability, so Lordship has even disposed of 6 cases recently. Say the writ is maintainable. There was order. Guwahati High Court also, Supreme Court also upheld it. They have not challenged that one also. So therefore, I will not take time. But within half an hour, I'll wrap up. I'll show this some annexures, High Court orders.
Can we do it now?
Yes, within 30 minutes, I'll show the order, my Lordship permission.
Mr. Debrat will have to.
He is here, and my school management
Yes.
also there.
School management is Mr. Singhal.
He's there.
Oh, school management is there.
Yes, yes.
Because they will be the one who would finally have to pay.
Yes, yes. Right. And here the problem here, now they are deferring the matter before this court. The management authority entering the school premises that if you win this case again, I will shut down the school. You have to go out. There's one aspect. Second, some of them are retiring. Retired benefits they are not paying, so you went to High Court. You wait for the High Court. This is also a matter. Therefore, the petitioners are extremely suffering.
They are saying,
we have to.
if they win and they pay, the school is shut down.
No, we have to.
I think it is not be the.
We have to dispose of this.
Yes.
The school
So I will
cannot
address.
be even closed in this way. In any school, it is not the things. I think it is wrong submission and given the some wrong information. I believe.
We'll hear the parties.
Yes, exactly. A high-ranking officer.
You see, as saying by my learned friend, it is covered case. According to me, it is not covered case because you see, when this first round of litigations come out regarding the pay and others, then as per my knowledge goes this long back, and at that point of time, this matters was come up. You see, this Assam public school when they had made the advertisement and that, and these matters, even one gentleman, his daughter was there, and then I was from the Union of India at that point of time. then from the Union of India, I just say just is in the advertisement given and it is banded to them. And RPS was in a bad situation. And after this, I think they given, and after this person has written the case differently. But here, Your Lordship, in this case, after this, all these officials come up to implement the fourth pay commission and fifth pay commission. Because of it, Your Lordship, in their appointment, it is that they will be considered their pay as per pay commission. So this was the matter. So how they have taken it is absent. But in this case, they are saying that this is we are challenging the maintainability due to this. In this petition, Your Lordship, nowhere he has written that it is purposely control of the central government. So we filed our affidavit that it is not purposely control of the central government, and they cannot say that it is the.
So you mean to say that Article 12 will not apply?
So it is in the society. In the society, it will not apply. And there is nothing has shown, but in fact the school is most of the school of the situated in the area of the Assam Rifle. So it is for welfare of the staffs. It was given the.
Anyway, we'll. You see, even if you at this point of time, see when the matter is finally heard, then the matter will be heard on merits as well as on the issue of maintainability.
They can say, Lordship permits, I would press for imposing a heavy cost upon the respondent. They cannot re-agitate the same issue again and again. I'll cite Lordship was an earlier occasion pointed out a recent Supreme Court judgment passed in the Army Welfare Association. That was I've gone through. I will show that still then these petitioners are entitled to benefits. So if Lordship permits, I'll proceed and he can come in, address and finish tomorrow. Only few annexures I'll show. Yes. My Lord, may come to advertisement, which they used to attract the best talent. Page number 93, Annex 6. Page number 93. 93.
Yes.
This is the advertisement they used to issue. And here they clearly mention purpose of principle. They mentioned pay scale and plus TA and other allowances as per government rules. So they, from the day one of the advertisement, all throughout they say that they will grant the benefits as per the government rules. Because of this, all these talented people, they join in the school. Now, my Lord, we come to page number 90 again, 90, regarding the fifth pay commission also. I'll not go beyond that.
Yes, sir.
Page 90, 90.
Yes.
Hello. This is the order passed by the authority itself. Chairman governing body ARPS has approved the implementation of Fifth Pay Commission report and sanctioned the revised pay scale of all the categories of staff, teaching, administrative, and grade 4 staff as per the pay scale laid down for the KVS for the above mentioned category of staff as per the details appended below. So Fifth Pay also they have granted as per the Fifth Pay Commission benefits. And their problems started, my Lord, Sixth Pay Commission was denied. When the Sixth Pay Commission was
okay, so the benefit of this Fifth Pay Commission has been
Fifth Pay they paid. They paid. Later on, the time came for payment of Sixth Pay benefits, they denied. Therefore, litigation started. My Lord, we come to page 101. Now, this is a single bench order. My Lord, may kindly see para 2, The petitioner 98 in number are employees, teaching and non-teaching staff of the Assam River Public School, RPS School, like or Shillong. They have moved this court by filing the instant writ petition with a prayer for issuing writ in the nature of mandamus and certiorari or other appropriate writ or other direction to the respondent to implement the recommendation made by the 6th Central Pay Commission. So that was this was denied. Writ petition was dismissed. My Lord, can you come to page 106, para 16. Learned single bench held that, my Lord, in view of the above, para 6, my Lord, in the considered opinion of this court, the Assam Rifle Public School is not an instrumentality of the state within the meaning of Article 12 of the Constitution, and as such, the petition is found to be not maintainable. So, learned single bench held that it is not maintainable. Now, being aggrieved with, we filed the writ appeal. The clearer copy may just a bit. The division bench of the Honorable Guwahati High Court. This was delivered on 5th September 2012. My Lord, may straight away come.
This is a writ appeal?
Yes, a writ appeal. Order pass writ appeal. I have even annexed here.
But why it's WPC? WPC number 140.
My Lord, this is the WA. The copy I have submitted is a writ appeal.
WPC 170, 140.
Two copies, I think. The two copies, I think. Another copy here, yes. Or you can see the other copy.
And what about this?
WA. May I just take it back? That one is, yes. That was so Xerox. The one I read out, madam. Printed 2 times. Yes, WA, man. And my Lord, we come to para 16 and 17. That is, my Lord, may I come to para 14, my Lord, we come to para 14. Para 14. Running page 17 at the bottom.
Yes.
As already noticed, the controversy is not about the equation of the employees of the school with the employees of KVS and GNV. It is about the liability of the school to extend the benefit of 6-pay CBSE to their employees in accordance with the terms and conditions of its affiliation to CPSE. At this stage, it may be noted by the office order dated such, which I have read out, my Lord.
Yes.
The governing body of the ARPS approved the implementation of 6-pay CBSE and sanctioned the revised pay scales and so on. So it's a reflection of the past one. And my Lord, may come to the next page. It's a lengthy paragraph. It refers to the advertisement also.
Yes.
And my Lord, may I come to para 15.
Yes.
In view of the above, the question to be considered now is whether the appellant can insist that such benefits of pay scales and tenures allowance admissible under the 6-pay commission be extended to them in total. In our opinion, the answer must be in the affirmative for more than one reason, as found by the learned single judge, with which we are in respectful agreement. The condition precedent for affiliation of any school to CPSE is that such school to pay salaries and allowances to their staff, which shall not be less than the corresponding categories of employees in the state government schools, or as per the scales prescribed by the central government. So it goes, and my Lord, we come to para 16.
16?
No other, yes, para 16, the next page. No other contentious issue survives for consideration. In our considered view, the learned single bench, having found that the respondent authorities are under obligation to pay the appellants the salaries and allowances payable to the corresponding categories of employees in KVS and NVS in the terms of pay by laws of CPSE regulating affiliation of school to it, however, would not have stopped there, but should have applied principle laid down by the apex court in such and such and allowed the repetition. She has in the process failed to exercise her rich jurisdiction of mandamus vested in her by the Constitution. After all, the legitimate expectation of the appellants are that the past and consistent practice of the school allowing them to enjoy the salaries and allowances payable to school run by or through the central government will continue cannot be discontinue without reasonable justification. Financial constraint cannot be a ground to deny the rights available to them under the law. Moreover, the respondent authorities are also barred by the principle of promise to appeal from breaking the promise held out by them in the advertisement that the teaching staff would be paid the salaries and allowances paid to the central government employees. Now, for the reasons stated in the foregoing, this writ appeal succeeds. Impugned judgment order of the legislature which is hereby set aside. The respondent authorities are directed to implement the pay and allowances in terms of 6 CPC to the teaching and non-teaching staffs of the school with effect from such, together with the increased tearness allowance with effect from July 2009, and the arrears payable in connection therewith, and extend the service benefits, including retirement benefits at par, with employees of KBS, JNVs, with arrears implement the applicable Assure Career Progression and STA to them without further delay. The entire exercise of implementation of the 6 CPC for the benefits of the appellant would be carried out by the respondent authorities within a period of 3 months from the date of receipt of this judgment. So this is the order passed by the division bench. Being agreed with this, my lord, they filed the SLP. The next, my lord, may come to page number 120. Management and the Union of India has preferred appeal. Page 120. This was dismissed on 21st July 2015. I'll come to that, the next page, page number, straight away, page 122.
122?
122. My lord. 120 is a SLP dismissal. My lord.
Okay.
120. May I just take the last paragraph. Petitioner very clearly submits that the sufficient time has been given by the petitioner for compliance of the order passed by the High Court in April. We therefore direct the petitioner to comply with the direction given by the division bench of the High Court while passing the impugned order, and pass the arrears to the respondents within a period of 8 months from the date. So Supreme Court said, okay, within 8 months you pay as per the direction of division bench. They filed a review petition, page 122. Review petition also dismissed. Page 123.
Yes.
And 124, my lord. After payment, they issued this notice to close down, for closing down of the school, 20 December. It says closing down of the Assam Rifle School, Light Corps. Please refer to the judgment of the Supreme Court of India dated sunset. Just, my lord, the audacity of the management. The Supreme Court by order dated sunset above has ruled that the staff of ARPS Light Corps, page 124.
24, yes.
My lord.
Yes.
Well, Light Corps be paid at 6 CPC scales, and all the arrears of with effect from 1st January 2006 to be paid by 20 March 2016. Post the judgment, the school management committee and board of governors have carried out due diligence on the financial health of the institution and concluded the school functioning cannot be sustained given the financial burden to the said judgment. In view of the aforesaid, it is humbly intimated that the school would be permanently closed down with effect from such, and your services in this school will no longer be required after 31st March 2020. Purely that they know very well before recruitment, they are sure that we will pay under the CPC recruitment, but they never pay it, they allow it to accumulate it. And when the court came to the rescue, pay it, and now they want to shut down. Immediately we rushed to this honorable court, and this honorable court has stayed that impugned closure notice. And when closure notice was stayed, they came forward for negotiation. And we were also ready, so we sat together. And my lord, may kindly see page 126. Is the proposal given by the petitioners. That, okay, if you face a financial crunch, though it is not, it cannot be attributed to me, it is the sheer negligence of the management, but to strengthen the financial position of the school, they also come forward. And I would take one, page 126, point number 1 at the bottom. The staff agree that the implementation of the 7th Pay Commission's recommendation Contempt be deferred by a period of 3 years from the dates of implementation as notified by the Government of India. They agree to work at the salaries and allowances currently being paid to them for the 3 years. So under the lower degree, however, the annual increment of 3% and the enhanced tenures allowance payable under 6 CPC shall be continued during the aforesaid period of 3 years. The staff agreed to voluntarily forego its STA and transport allowances. This will also itself generate approximate 29 lakhs annually to the school. The staff agreed to voluntarily forego its LTC allowance for a period of 3 years, commencing sunset. The staff also agreed to voluntarily forego its perks allowances pertaining to free electricity and free semi-furnished accommodation. Staff agrees to pay their children's tuition fees of sunset, because earlier they promised that we don't need to pay. Conversion to provident fund from CPF to EPF through adverse to the interest of the staff are agreed by them, pursuant to the ceiling as such. However, the remaining direction passed by the High Court by sunset and affirmed by Supreme Court in its daily sunset will be implemented in latent speed. So this is the proposal given by the employees, given out certain benefits. Thereafter, page number 131, my Lord, can you see Director General has filed a affidavit before this honorable court. And I may take para 5, para 5.
Yes.
It says the deponent in his capacity as a DG at the outset submits a gesture of goodwill and his commitment to continue running the school. He is willing to convert the loan granted to the ARPS of rupees 2.5 crore as a one-time grant to the school to reduce the financial burden of the school, which in turn will reduce the financial implication on the parents vis-a-vis fee hike. So he contributed. And lastly, my Lord, we come to page number 138.
Yes.
138, para 9. The deponent states that a last measure, deponents again directed the patron of the school to hold a meeting with the present petitioners and parents of the wards of the school and representatives of the NAC or such to try and come to a solution to this entire impasse so that the decision of the board governors can be reviewed and school be kept running. So he also encouraged for a meeting between the stakeholders. Meeting were held. My Lord, kindly come to page 139. Meeting was held on 30 March 2016. And my Lord, I may take to save Lordship time. Para 11, page 140. Proposal given by them also consider. A clarification regarding the proposal of the staff pertaining to their foregoing ST and TT allowances was sought by the person. He asked the nominated staff to clarify whether they were proposing to forego STA and TT allowance for the next 3 years or permanently, as it was not emerging clearly in the proposal forwarded by the staff. On this issue, the staff clarified that they will forego STA and TT allowances permanently. So this is the minute reflected. And they insist for further proposal, and may show another proposal, page number 141.
Yes.
Yes, ma'am. The last paragraph may I take, ma'am. In view of the facts and circumstances stated above, we hereby put for the following further proposal for your kind consideration. These fresh sets of proposals are in continuation of the earlier set of proposals submitted on 26 March and may therefore be read as a composite set of proposals. The staff is agreeable to voluntarily forego enhanced attendance allowance for a period of 1 year starting from 1st January 2016 to 31st January 2016. To put it more clearly, the staff is ready to work at the same TA currently paid to them up to 31st December 2016. However, from 1st January 2017, the TA will be at par with the central government. No area for the aforesaid period would be paid to the staff. So this is their proposal again. Now, after this, what happened? The DG has filed, the respondent has filed the affidavit. My Lord, may kindly come to page number 151. The last affidavit. In view of this approach adopted by the parties, they also agreed. And when they filed this petition, affidavit, my Lord, for the respondent. My Lord, may kindly take para 3. My Lord.
Yes.
It is categorically stated that existing service conditions of the regular permanent employees Assam Rifle Public School Light Course Shillong, petitioner herein cannot and will not be changed or altered as the same has attained finality by orders passed by this Honorable Court and affirmed by the Apex Court. So they gave an assurance before the court that we will not change the service condition. Service condition includes payment of the salaries and benefits. So they assured that we will not change it. They came forward giving up some benefits. So we accept that one, that we will not change it. So in view of this position, my lord, the petition was closed, page number 153. Well, yeah, I may take the second paragraph, page 153.
Yes.
It says, in response, Mr. Gable, learned counsel appearing for the respondent, number 2, these are the management, candidly submitted that with the proceedings that have taken place pursuant to and in conformity with orders of this court, and when the matter relating to service condition has attained finality with the decision of this court and the Honorable Court, earlier notice of proposal clause has already lost its relevance and is redundant, and the respondents could neither change or nor do they propose to adverse the other the existing service condition of the concerned employees. During the course of the submission, Learned Such has also placed on record an affidavit of the authorized officer of contesting respondent stating sunset. Take up the same reproducible. With reference to the submission so made and the affidavit so filed on behalf of the contesting respondents, Learned Counsel for the petition has now clearly submitted that with the decisions that have been taken and in view of this substantial development that have been taken place during the course of hearing of this petition, where the parties have otherwise reached to a mutual agreement and other pending aspects are also proposed to be amicably settled, nothing of any dispute remains. Taking note of the submission so made, this court finds that parties are present at no issue and therefore nothing, any adjudication is requisite in this writ petition. In view of the above and with the observation following, this petition stands disposed of. So matter was closed there. And they supposed to pay, they run the school again, and white page 152, 155, one of the principal of the same school also denied the benefits, so he also filed a writ petition, and this oral court passed an order granting the benefits. Because they didn't go for appeal. And what happened, my lord? Thereafter, we asked for payment of the 7-pay benefits. My lord, they did not attend to. And therefore, my lord, we kindly come to page number 164, the representation filed by these writ petitioners. May I come first to, with lordship permission, page 161.
160?
161. This is the first representation.
Okay. Is the first representation?
Yes, my lord. Representation.
Yes.
May I take the meter, however, may I start. However, it is extremely hurting when we do not receive what is due for us at the right time and in the right way. We fail to understand as to why we are forced to submit our requests every time for the release of our financial benefits like DA, 7-pay, CPC, and such. At present, we are anxiously waiting to receive the attendance allowance announced by the central government since July, such, which is yet to be released in spite of the repeated and verbal assurances. So this is the first representation. They didn't respond. My lord, may come to page page 165 also. Another reminder was put forward for their consideration. It says, please refer the letter dated 9 May 2022 and the Honorable High Court order dated such and the Supreme Court order dated such. Release of tenants allowance which are pending since July such. Implementation of pending such and such. Implementation of 7-pay which is due since January 2019. They have given up 3 years. Otherwise, it would be from 2016, January 2016. But since they have given up because of the negotiation, they entitled from January 2019. This was not attended to. The last was, my lord, representation was put up, page number 160, my lord, 68.
160?
168.
9.
168.
169 or 168?
168. A short reminder to them. But they did not.
Yes.
Now, in the affidavit, I will not take that affidavit again. The affidavit, they take the same plea. Writ is not maintainable, my lord. And in view of the change of a Supreme Court decision passed in St. Mary's case, you are not entitled. The writ is not maintainable. So those, then they have taken again. And now, my lord, similar plea was raised before this Honorable Court, and Lordship has passed this order. When we came here, what they attempted to do, they tried to divide the permanent employees. And ERPS is only one school run by the single society. And now another school is run by the Assam Rifle Welfare Society, spread over the entire Northeast, run by different school, different society. Now they merged together. So after merging it, the employees of this ARPS would be scattered. That a demo was made. Immediately at the same time, some of the teachers were transferred. Agree with that, we filed a writ petition before this court, and Lordship has passed the order. My lord, may I just take the relevant paragraph? Only one paragraph.
This order was this order a sale?
Not a sale. They accepted it in finality. My lord, may kindly take the pain to come to the flag mark which I made. Para 63. Taking into account all the submission given by all the parties.
This one.
Para 63.
Yes.
63, my lord, I need you with me. In view of the above, this court would respectfully hold the view that the respondent ARPS, though being a private unaided education institution, however, because of what was held in the case of Chairman Assam Rifle Public School and others versus Makanmi, Genku, and Supra, therefore, it is deemed to be a state within the meaning of Sanskrit Article 12 of the Constitution. Accordingly, it is amenable to writ jurisdiction under Article 226 of the Constitution. Most of the parties involved in the earlier case are also parties in these present proceedings. Another factor which could weigh with this court is that since this court itself in the division bench has held that ERPS is an amenable writ jurisdiction, no departure can be made in this regard by the single bench of the same court. Under such principle, this court would hold that these petitions are accordingly maintainable. They did not go for appeal. It has attained its finality. Now, then we file this petition. Now they take up the same plea again. It is not maintainable. There is a limit. But if they are not the contesting parties, we would understand. But they are contesting parties. Now, development of the law, it is my duty to place, my lord. And my lord has pointed out earlier occasion also that recently the Honorable Supreme Court held that the school run by the Army Society is not maintainable. However, Supreme Court did not end up there. Supreme Court reevaluated the development of law, quoting the order passed in the St. Mary's case, heavily relied by the respondents, and passed the order. I would take, my lord, come to, my lord. My lord, we come to para 38 of the judgment, turning page reflected at the bottom, page 47. St. Mary's case where my two learned friends are heavily relying, that also referred by the Supreme Court.
This one.
Para 38, 38. And after 38, my lord, have a look. Running page 47, referring to St. Mary's decision. And I would again...
Running page
47. Page is mentioned at the bottom.
Yes.
My lord, may mark it para 38. And thereafter, my lord, I would take again to para 42, running page number 82. After, my lord, examining the evolution of this concept of law, Apex Court held this.
Yes.
My Lord, may I read, my Lord? In view of the aforesaid, nothing more is required to be discussed in the present appeals. We are of the view that the High Court committed an egregious error in interpreting the writ petition filed by the respondent herein, holding that the appellant society is a state within Article 12 of the Constitution. Undoubtedly, the school run by the appellant society imparts education. Imparting education involves public duty, and therefore public law element could also be said to be involved. However, the relationship between the respondents herein and the appellant society is that of an employee and a private employer arising out of a private contract. If there is a breach of covenant of a private contract, the same does not touch any public law element. The school cannot say to be discharging any public duty in connection with the employee of the respondents. So it says that though the imparting education is a public function is involved, but the contract between the employees and employers are private in nature, so it is not maintainable. Now, my Lord, we see the doctrine of legitimate expectation. Even assuming that the argument advanced by the parties, other side is acceptable. If they are not the party, they could take this plea of Supreme Court that it is not maintainable. But since they were a party, and between the same party, court has passed an order, and then is finally, in fact, they are precluded to raise this issue. But even they are allowed to raise the issue, assuming they are right, my Lord. Supreme Court went further. And the next paragraph, doctrine of legitimate expectation. Even my case is safe by this. Okay. Paragraph 43. During the course of the arguments, a submission was canvassed that the respondents were under a legitimate expectation that their service condition and salary would not be unilaterally altered by the appellant society to their disadvantage. Thus, as the respondents were neither consulted with nor taken in confidence by the appellant society, therefore, affecting the try to follow.
Page number?
You can follow it. It is not help this.
Page number?
Try to follow the We'll submit to you if there's some discrepancies there. Affecting the changes in their service conditions, it amounted to the breach of their legitimate expectation, thereby making a fit case for the exercise of jurisdiction by the High Court. The doctrine of legitimate expectation was also referred to and relied upon by the single judge of the High Court as of one of the reasons to allow the writ petition filed by the respondents. The relevant observation made by the learned single judge in this judgment order that is such a reproduced below. My Lord. We also have to appreciate the legitimate expectation of the petitioners who expect equity, fair play, and justice from a public authority, which respondents number 2, 3, and 7 indeed are, and therefore they must meet such a standard as a public authority ought to 15 have. The new management of the school, including respondent 2, 3, and 7, are hereby directed not to change or vary the conditions of the petitioner to their disadvantage. Before parting with the matter, we deem it necessary to answer the aforesaid submission of the respondent. This court, in the Union of India versus Sanders and such, enunciated that the doctrine of legitimate expectation is a creature of public law aim, combating arbitrariness in executive action by public authorities. It held thus: time is a threefold present. The present as we experience it, the past as a present memory, and future as a present expectations. For legal purposes, the expectation cannot be same as anticipation. It is different from a wish, a desire, or a hope, nor can it amount to a claim or demand on the ground of a right. However earnest and sincere a wish, a desire, or hope may be, and however confidently one may look to them to be fulfilled, they by themselves cannot amount to an ascertainable expectation, and a mere disappointment does not attract legal consequences. A pious hope, even leading to a moral obligation, cannot amount to a legitimate expectation. The legitimacy of an expectation can be inferred only if it is founded on the sanction of law, or a custom or an established procedure is followed in regular and natural consequence. Again, it is distinguishable from a genuine expectation. Such expectation should be justifiably legitimate and protectable, Every such legitimate expectation does not by itself fructify into a right, and therefore it does not amount to a right in the conventional sense. In Ram Prakash Singh and such, this court explained the doctrine of legitimate expectations in detail as follows. What is legitimate expectation? Obviously, it is not a legal right. It is an expectation of a benefit, relief, or a remedy that may ordinarily flow from a promise or established practice. My Lord, promise, keep in mind. The term established practice refers to a regular, consistent, predictable, and certain conduct, processes, activity of decision-making authority. My fault under this, consistently they are paying this. The expectation should be legitimate, that is reasonable, logical, and valid. Any expectation which is based on a sporadic or casual or random acts or which is unreasonable, illogical, invalid, cannot be a legitimate expectation. My case is, my Lord, if Lordship can see, it is not sporadic. They consistently pay it, even they comply with the order. They made a commitment before this court also. Not by being a right, it is not enforceable as such. It is a concept fashioned by the courts for judicial review of administrative action. It is procedural in character based on the recruitment of a higher degree of fairness, higher fairness in administrative action as a consequence of promise made or practice established. In short, a person can be said to have a legitimate expectation of a particular treatment if any representation or promise is made by any authority, either expressly or impliedly. I don't really see. Or if the regular and consistent past practices of the authority gives room for such expectation in the normal course. As my Lord, my case fall under this category. As a ground for relief, the efficacy of the doctrine is rather weak, as it's just above fairness in action, but far below promissory estoppel. It may only entitle an expectant to an opportunity to show cause before the expectation is detached, or to an explanation as to the cause for the denial. In appropriate cases, the court may grant a direction requiring the authority to follow the promise, procedure, established practice. A legitimate expectation, even when made out, does not always entitle the expectant to a relief. Public interest, change in policy, conduct of the expectant, or any other valid or bona fide reason given by the decision maker may be sufficient to negative the legitimate expectation. The doctrine of legitimate expectation based on the established practice, as contrasted from a legitimate expectation based on a promise, can be invoked only by someone who has a dealing or transaction or negotiation with an authority on which such established practice has been appearing, or by someone who was a recognized legal reputation with the authority, a total stranger in connected with the authority, or a person who has no previous dealings with the authority and who has not entered into any transaction or negotiation with the authority cannot invoke the doctrine of legitimate expectation merely on the ground that the authority has a general obligation to act fairly. In Jitendra Kumar Singh, this court, while differentiating between the legitimate expectation on the one hand and anticipation, wishes, and desire on the other, observed that a legitimate expectation is not the same thing as an anticipation. It is distinct and different from a desire and hope. It is based on a right, says and such. It is grounded in the rule of law as requiring regularity, predictability, and certainty in the government's dealing with the public. We have no doubt that the doctrine of legitimate expectation operates both in procedural and substantive matters. A reading of the above decisions bring forth the following features regarding the doctrine of legitimate expectation. First, legitimate expectation must be based on a right as opposed to a mere hope, wish, or anticipation. Number two, madam. Secondly, legitimate expectation must be arise either from an express or implied or consistent past practice or custom followed by an authority in its dealing. But my case squarely fall within B. Thirdly, expectation which is based on a sporadic or a casual or random acts, or which is unreasonable, illogical, invalid, cannot be treated as a legitimate expectation. My lord, this is not here. It is not a sporadic. It's not casual. Litigation after another, and they file an affidavit before this court that we will not change it because that is already attained finality. It's not sporadic. is a consistent. Fourthly, legitimate expectation operates in relation to both substantive and procedural laws, relations, methods. Fifthly, legitimate expectation operates in the realm of public law. That is, a plea of legitimate action can be taken only when a public authority breaches a promise, deviates from a consistent past practice without any reasonable basis. It is exactly my law. They want to debate it. Sixthly, a plea of legitimate expectation based on a past practice can only be taken by someone who has dealing or negotiation with the public authority. Exactly these people. It cannot be invoked by a total stranger to the authority, merely on the ground that the authority has a duty to act fairly. The aforesaid features, although not exhaustive in nature, are sufficient to help us in deciding the applicability of the doctrine of legitimate expectation to the facts of the case at hand. It is clear that legitimate expectation jurisprudentially was a device created in order to maintain a check on arbitrariness in state action. It does not extend to or cannot govern the operation of contracts between the private parties, wherein the doctrine promissory estoppel holds the field. Even now, Guwahati High Court said that promissory estoppel has come into play between the two. That also. We have discussed in detail in preceding paragraphs that even if the function being performed by a private education institution in imparting education may be considered as a public function, relation between the administration of such an institution and its employees remain a contractual one, falling within the ambit of private law. Nothing has been placed on record by the respondents to show that any express or implied promise was made by the appellant regarding keeping their salary and service condition intact. There have been no past negotiation or dealings between the respondents and the appellant society as the dispute arose as soon as the appellant took over the administration of the school. But there was no past negotiation between the parties before the Supreme Court. The school management was run by the One Society, the Welfare Society, and the earlier One Society, and Army took over. There was no past negotiation between the parties. The Supreme Court observed that one. Moreover, there is no statutory obligation on the appellant society which requires that the salaries and allowances of the respondents are to be kept at par with what is payable to the government institutions. The distinction, Lordship kindly say, in my case, advertisement or service rule clearly say that it will be as per the government rules. But here in this case, it is not. Lastly, the appellant society, for the purpose of its relationship with employees, cannot be regarded as a public or government authority. We are of the view that all the aforesaid reasons, the doctrinal legitimate explanation will have no applicability to the facts of the present case. The submission of respondent in that regard is thus answer accordingly. Why not? Now, the last one, may I just take the para 54, the last paragraph. Yes. Although we have set aside the High Court judgment and all passed by the High Court, yet having regard to the submission made on behalf of the appellant as recorded in the paragraph 6 of the order is such, as also the fact that all the respondents on date are serving with the appellant society, they shall continue to serve on the terms and conditions as stipulated by the appellant society. The appellant society shall not discharge the respondent from their service. So it is a change of a service condition. Earlier, the school was run by the One Society, and the Army took over the school management, and because of the change of service condition, this case cropped up. And Supreme Court say that allow them to continue. But here, legitimate expectation also. It is very clear. Here is a past dealings, past promises made consistently from the day one of the advertisement. High Court intervention, Supreme Court intervention, round of litigations before this court, they complied with. In fact, it is absolutely precluded them to revisit the same issue again and again. Therefore, it is a cover case. My humble submission, I will not drop only one judgment for Lordship permission. One of the law point, 2013 volume 5. How the Apex Court says. If 2013 volume 5 SSC page number 252. Relevant para 44. And it is very, very clear, man. The manner in which the respondents are advancing is similar argument advanced before the Supreme Court. And the Supreme Court says that will change the law every now and then in that case. My Lord, I'll come to para 44. I'll take this para and rest my submission. Para 44. Even though, strictly speaking, res judicata may not be applicable to the proceedings before the central government. The High Court, in exercise of its power under Article 226, was certainly entitled to take into consideration the previous history of litigation inter parties to decline the relief to the appellant, merely because the High Court has used the expression that the claim of appellant is barred by res judicata would not necessarily result in nullifying the conclusion, which in fact is based on consideration of equity and justice. Given the history of litigation between the parties, which commenced in the 1950s, the High Court was justified in finally giving a quietus to the same. The subsequent interpretation of Rule 25A by this Court, that it would only prospective operation in Salingam case, would not have the effect of reopening the matter which was concluded between the parties. In our opinion, if the parties are allowed to re-agitate issues which has been decided by a court of competent jurisdiction on a subsequent change in the law, then all the earlier litigation relevant thereto would always remain in a state of flux. It's very, very clear. Supreme Court is say that in a subsequent change of law or Supreme Court interpretation in subsequent changes, in that event, all decision rendered by the court earlier will be in the situation in the nature of flux, uncertain. It will be revived, reopen everything. That is impermissible. In such circumstances, you say at the end, the last portion. In such circumstances, every time either a statute or provision thereof is declared ultra vires, it would have the result of reopening of the decided matters within the period of limitation following the date of such decision. In this case, not only the High Court had rejected the objection of the appellant to the substitution of the legal heirs of the Dr. Sanjay Pradhan in her place, but the SLP from the said judgment also been dismissed. Even though strictly speaking, the dismissal of the SLP would not result in the merger of the judgment of the High Court in the order of this court, the same cannot be said to be wholly irrelevant. The High Court, in our opinion, committed no error in taking the same into consideration in the peculiar facts of the case. Ultimately, the decision of the High Court was clearly based on the facts and circumstances of this case. The High Court clearly came to a conclusion that the appellant had accepted the locus standi of the LRs of Dr. Sarojit Pradhan to pursue the application for the mining list before the central government as well as in the High Court. So it is very clear, my lord. Supreme Court is very clear that you cannot, once the issue brought by the parties is consciously debated and decided by the court of law, subsequent change of law by legislation or subsequent change of interpretation of law by the court will not affect the decided matters. Admittedly, in my case, all the decisions rendered by this Supreme Court, party cannot change, party cannot revisit again and again. So my humble and respectful submission is, in fact, Lordship may kindly consider and pray. May I just submit these updates for the Lordship? I prepared. The short list are the gist of the matter. I can feel. So my respectful submission, my Lordship may kindly consider the writ petition.
So we'll hear the other parties next date. Yes, yes, Leslie.
Hopefully the next day it will be finished, madam.
Mr. H.L. Senior Counsel for the appellant, for the petitioner, who has concluded his argument. The respondents will respond to the same on the next date fix. As agreed to by the parties, release this matter after 3 weeks.
2 weeks, otherwise it will be forgotten again. Subject Lordship convenient.
Require some time, my lord. Many judgments have been referred by the landlord.
They have a holiday, holidays.
My lord, we have
11, 12.
Let it be.
I have no problem. Otherwise, if postponed for a long time, then it will be.
My lord, let it be 3 weeks, my lord. We need time.
3 weeks will be too long. Subject Lordship convenient. Otherwise,
3 weeks, my lord. It will not be possible, my lord. Many judgments have been realized. We have to go through the entire, all those judgments, figure out all that.
Okay.
I'll do my best.
Item number 40.
Deeply obliged.
Please, Your Lordship. Your Lordship, I've mentioned earlier this item 14. It seems like it hasn't been recorded.
Yes. Oh no. On premier, you for petitioner?
Yes, for petitioner, Your Lordship.
This is matter after
3 weeks. Your Lordship.
Any mention?
Lordship, I beg to mention item number 7. This matter may come up after 2 weeks, Lordship.
On premier by the appellant, this is matter after 3 weeks.
Yeah, please, Your Lordship. I beg to mention item number 5, my lord.
On premier with the appellant, this is matter after 3 weeks.
My lord, item number 6 also, my lord. Item number 6, 5 and 6.
Same.
Yes. But different cases, my lord.
They're not connected
cases.
matters.
It's not connected.
They're not connected matters, Lordship. Different.
Okay, that's matter. Same lawyer.
Blood.
The supplementary list, item number 1.
Please, Your Lordships. Lordship, this is an appeal against the order passed by the learned single judge. Lordship, the matter pertains to the post of the headman of Maungap Kleshnong village. Your Lordship had an occasion dealt with this matter. Your Lordship had passed an order for direction for holding of an election to the post of headman. Now, pursuant to Your Lordship's order, the Hima Lingdo has has directed for elections, Your Lordship, and they had prescribed the eligibility conditions criteria of the headman. Now, the election was supposed to be conducted on 18/2/2025. Now, the respondent number 5, who was the then headman, he was removed from the post of headman because of the misappropriation of funds that he had received regarding land compensation. Now, he is aggrieved by those eligibility conditions. Now, on the fact end of the election date, Your Lordship, he had approached this Honorable Court. Now, this Honorable Court, Your Lordship, has passed certain orders. Lordship, may kindly come to page. Lordship, may kindly come to page 53.
Yes.
This is Your Lordship's order, which was passed in the writ appeal, which was preferred by one of the parties herein. Your Lordship, at page 56 at paragraph, page 53, Your Lordship, at paragraph 15, this Honorable Court had directed that election should be held to the post of headman within 1 month from the date of receipt of the certified copy of this order. Now, thereafter, Your Lordship, the elections were notified to be conducted on 18/2/2025. Now, the Hima Lingdo Lordship has prescribed certain conditions regarding the eligibility of the headman. Now, aggrieved by those eligibility conditions, the respondent of 5 had preferred a writ petition at page 55.
Writ petition?
Lordship, at page 55, he has preferred a writ petition WPC 39 of 2025. And this, the learned single judge, at that relevant point of time, Your Lordship, may kindly come to page 56 at paragraph 4, Your Lordship. Paragraph 4, the respondent, paragraph 4, my Lord,
yes.
I'm allowed to be read. Mr. S.R. Lingdol, learned counsel for petitioner, has drawn the attention of this court to the conditions dated 12/2/2025, wherein a point number 4 thereof it has been laid down that a person who has acted or litigated against Hima cannot contest for the position of Rambashnong. This, he submits, is against all norms of election process and has been inserted in the conditions just to make the petitioner ineligible to contest for the said post. It is further submitted that he has received the said conditions only on 14/2/2025 itself, on the last date of the nomination, and as the illegality being large in the entire process, some appropriate orders may be passed in this regard. Now, the learned single judge, Lordship, at page 57, para 7, had said that since the election is already at the advanced stage, election should be conducted and the result should be kept in a seal cover, Your Lordship. Now thereafter, Your Lordship, the said repetition was again listed on 18/3/2025 at page 61, Your Lordship. There's another order passed by the learned single judge. Now the direction is at page 63, para 5.
Yes.
Now, since the respondent 5 was aggrieved with the eligibility conditions of the election, he was given an opportunity to prefer a political appeal before the respondent district council, and that the respondent district council should pass necessary orders, Your Lordship. Now he has preferred that political appeal. Now the order is at page 65, Your Lordship. This is an order passed in the political appeal by the respondent district council. Now at page 67 is the finding of the executive committee, Your Lordship. Page 67.
Yes.
The executive committee in this proceeding, Your Lordship, had directed that had opined that the election which was conducted on 18/2 that should be declared null and void, and whatever eligibility condition that was imposed by the HEMA, that is not as per law. So by this order, the HEMA was again directed to proceed to conduct a fresh election. Now, Your Lordship, aggrieved by this order, we had preferred a writ petition challenge this order, Your Lordship. Now, a primary ground or challenge before the learned single judge against this order is that, number one, Your Lordship, the respondent number 5, he never filed his nomination papers, Your Lordship. So number 2, the condition laid down by the HEMA is not against him or per se, but it's in the interest of the public at large. Because here the factual aspect of the matter remains that the respondent number 5 has misappropriated certain funds which he had received while he was the headman at that relevant point of time, Your Lordship. Now that condition which he has assailed, Your Lordship, that in a humble submission is that is not against him per se, but that is against in the interest of the public at large, Your Lordship. So our ground is that conducting a fresh election at the behest of the respondent 5, that is not correct, Your Lordship. So we had approached the honorable single judge for direction to declare the results, Your Lordship. Now the appellant herein is one of the candidates who had contested the election. Now, because at the behest of the respondent 5, Your Lordship, a fresh election was directed to
Who
be
has
conducted.
filed this political appeal?
The political appeal was preferred by the respondent number 5, the then headman.
Okay. Not the petitioner.
Not the petitioner, Your Lordship. Because, Lordship, I've shown Your Lordship at...
Okay, so the then headman had filed the political appeal, and this
order was
and this decision at page 67 says that the fresh election to be conducted.
Conducted, Lordship.
That was done.
No, Your Lordship. Aggrieved by this order, we had approached the learned single judge. Okay. Now, our primary ground is that whatever election that was conducted, with the certain eligibility condition, Your Lordship, I had contested in the election, and the elections was already conducted. Now the results was preserved in a seal cover, Your Lordship, by the direction of the learned single judge. Now by this order, it's the entire election conducted on 18/2/2005 was declared nullified. So we are of the our ground is that the election, whatever election that was conducted on 18/2/2005, that should be declared by the respondent district council, and not by declaring that as null and void, and to direct for further fresh election, Your Lordship. Because in that particular election, Your Lordship, the respondent 5 has never filed his nomination papers also. He never even approached the election committee to even apply or to even ask for a nomination papers. So in my humble submission is that at the behest of the respondent number 5, Your Lordship, the fresh election cannot be conducted, Your Lordship. Now, while this order was passed by the...
But respondent 5, how did he figures in the whole, whole scheme?
Lordship, respondent number 5 was the then headman. He was removed. He was removed from the post.
That's why he was the one who had preferred this political appeal.
Yes, Lordship.
Okay, that's what.
Lordship.
Because you had given a picture that this was filed by the then headman. Respondent number 5 is not the headman, not the eligible candidate, and all those things.
Respondent number 5 was the headman at that relevant of time.
But he was not one of the contesting candidates.
He was not one of the contesting candidates. That is our primary ground, Your Lordship. So this order could not have been passed because he never filed his nomination papers also to this particular election. So by declaring the election null and void, that is not correct per se, Your Lordship. So, Your Lordship, the learned single judge, what it has done is that it has upheld the order passed by the executive committee, Your Lordship, and the election it has been directed to be held within a period of 30 days. So, Lordship, we are at this stage now that likely that the election will be announced by the Lingdo Hima, Your Lordship. My submission at this stage is that Lordship notice will be issued, and till such time the election should be, the order of should be stayed, Lordship.
Process has not started.
Process, no, Lordship. Process has not been started.
Impugn order dated 3/9.
3/9. 3/9/2025, Lordship.
Have you filed a separate application for stay?
I have filed a separate application. In this case, 87 of 25, Lordship.
Oh, who has appeared? Oh, yeah.
Your Lordship, I have received instruction to appear, Your Lordship, and I'll be filing my power on the close of the day. Lordship, what remains of the entire...
There's no caveat.
No, Your Lordship. I received instruction of the matter being listed today. I'm giving appearance and will file my power on the course of the day. Your Lordship, what remains of the matter is that this Maunga Krishnong, there is no headman to look after the affairs of the entire village. And the entire public policy, the entire public interest is at stake. Now, Your Lordships, the post of headman is lying vacant for the last 1 year. So, Your Lordship, as per the order passed by the respondent KHDC, is as per the new Act 2023 to conduct a fresh election, and even as per the order, the impugn order of the learned single judge, is for conduct of fresh election. That's for fairness, and the entire judgment is passed on principles of fairness and equity, Your Lordship. Unless the other allegations of which they have raised against me on the grounds of misappropriation of funds, a separate suit has been instituted, Your Lordship, for any other issues regarding the money. But we are concerned here about the post of headman, Your Lordship, which has been lying vacant. So, Your Lordship, for the interest of justice, this impugn order was passed that fair election be conducted and an observer be appointed. Your Lordship, the entire matter, what comes, the consequences of who gets elected as a headman is a choice of the villagers who elect them. So, Lordship, this is just a dilatory tactic, just to avoid any form of for conduct of fresh election. And so far, as per the instruction received, there has been no announcement made so far with respect to the compliance of the order. Within the 4 weeks, that announcement should be made for conduct of the election to the post of headman in the Maunga Krishnong village. So, Your Lordship, is that my humble prayer is that the order should not be stayed in the election process be conducted for fairness. Lordship, there has been many such other grounds and reasons which the villagers they have taken to the street to protest against the action of the respondent Mofo, which is the Lingdo, for the purpose to conduct the election. And the appellant here, Your Lordship, is just he took part in the election, and one of the conditions it has breached, it has prejudiced me not to allow me to contest the election at first instance when I have filed a writ petition before the single judge. So my humble prayer that the election process should continue. Otherwise, Your Lordship, the entire village will be at chaos. Now there's nobody to look after the affairs of Maunga Krishnong till present.
That is incorrect, Lordship. The
But
acting
see,
headman is in
but
place.
the fact remains that an appeal has been filed against the order directing fresh election to be conducted.
Yes, Lord.
So that has to be heard by us. See? And then if we allow the process to continue, then the appeal become redundant then, or infructuous.
Your Lordship, Your Lordship may recall, as my little friend, he has apprised Your Lordship that the Lingdo has filed a writ appeal. He wants to conduct the election. We do not have any objection if the Lingdo will conduct the election in a for fairness in a fair process as per the election procedure. So presently also, Your Lordship, we are having the same contention.
As far as you are concerned, you would insist on a fresh election process.
Yes.
But they are saying that the process that has already been conducted, result already in the seal cover, that should be maintained.
Not true.
That's there. So conflicting contention. We'll hear all the appeal.
Lordship, may issue notice.
And who? How many respondents are there?
So there are 5 respondents.
Okay.
1, 2, 3 is district council.
All present.
No, Lordship.
No, Lordship. Respondent number 4.
The Lingdo is not represented.
Don't stay. Stays. Exactly. Heard Mr. Melon Pure, counsel for the appellant. Who has submitted that the appellant being dissatisfied, being aggrieved and dissatisfied with the order dated 3/9/2025 passed by a learned single judge of this court in WPC number 199 of 2025 has now approached this court with a prayer to set aside and quash the said impugned judgment. The respondent number 1, 2 and 3 respectively are duly represented by Learned Counsel Mr. Respondent number 5 is also present through Learned Counsel Mr. Arvindo, who has submitted that he may be allowed to file his power within the course of the day. As such, formal notice on the said respondent number 1, 2, 3 and 5 are not necessary to be issued. However, the appellant is directed to take steps for issuance of notice on respondent number 4, the same returnable within 2 weeks. You need to prepare a paperwork.
The entire documents.
I think this is
enclosed.
On appearance of the parties matters, the matter will be heard accordingly. Where is the miss case?
This case 87.
Eখানে মিস কেস Mr. Headman of Pure Counsel. For the petitioner has submitted that the should be applicant, isn't it? Mr. Nopio, petitioner or applicant?
I've mentioned petitioner.
Kunun to petitioner has preferred an appeal against the judgment and order dated 3/9/2025 passed by the Learned Single Judge of this court in WPC number 199 of 2025. The effective order in the said judgment is the direction of the third single judge for a fresh election to be conducted as regard the post of headman of Maungap Kli Snow within the this is called what CMship or citizenship? Lingdorship of Lingdor Moplang. However, in view of the fact and the timeline given for the said election to be conducted is 4 weeks from the date of the said order dated 3/9/2025, the same which will expire in the next few days. At this juncture, at this stage, the Learned Council has submitted that the impugned judgment may be stayed so as not to render the appeal infructuous before the same is heard out. We have considered the submission made, and at this point of time we are inclined to allow the prayer of the petitioner. Accordingly, the operation of the said impugned judgment and order dated 3/9/2025 hereby stayed until further orders. The stayed in the interim until further orders. The respondent, including the respondent number 4, who is to be served with notice, may file their response to this application for the same to be finally disposed of. This matter after 3 weeks.
I'll take steps upon respondent form.
Anyway, since all the papers are ready, on the next date, if all the parties appear, we'll hear.
Finally.
Item number 2.
Please, Lordship. This is a criminal appeal, Lordship. I've been convicted under Section 302, sentenced for life imprisonment, Lordship. It's, however, Lordship, a delay of 338 days. The condonation application is coming up today. Primarily, Lordship, I've made the...
Really?
Yes, Lordship. 338 days. Essentially, Lordship, the appellant herein, he's suffering from a mental health issue. He's been diagnosed with schizophrenia and bipolar disease. So, I've made a vermin, Lordship. If your Lordship will kindly come to page number 3, paragraph 4. He's been inside and outside of Mimhams Hospital to and fro. I've also annexed my medical reports, Lordship. So, it's been difficult for us to communicate with him. It was only in the month of September, Lordship, that we were able to write to the Superintendent of Jail to furnish us the medical documents. We were able to communicate with him. And it was only in the month of 21 August 2025 that we were able to apply for certified copies. That is at page 17, Lordship. We received on 10th of September. I humbly pray that the delay may be condoned, Lordship.
Yes, who's appearing?
Lordship, since the grounds have been made on medical reasons, state will not object, Lordship.
What, Mr. Then you are legal aid counsel?
No, Lordship. Private matter, Lordship.
I was asking you earlier whether it's a legal aid matter. You said yes.
I apologize, Lordship.
Anyway, Mr. Learned Counsel, who has submitted that the petitioner herein has filed an appeal being aggrieved and dissatisfied with the order, with the judgment
16/8.
dated 16/8/2024 and the related sentence dated 20/8/2024 passed by the learned sessions judge. Area is the Anti-Hate District in Sessions Case number 46 of 2021. by which judgment and sentence the petitioner was made to undergo imprisonment, undergo life imprisonment. However, because of the condition of the petitioner, who is having mental health problems and was admitted at Mimhan Shillong, and other reasons, the appeal could not be filed in time, thereby a delay of how many days?
338, Lordship.
338 days has occurred. It is prayed that the delay may be controlled and the appeal be admitted. Yeah, that one. Miss Angela Leonard, Senior GA, appearing for the state respondent, has no objection to the prayer made on the grounds stated. Accordingly, on consideration of the prayer made, the delay in preferring the related appeal, the delay of
338, Lordship.
338 days in preferring the related appeal is hereby condoned. Registry is directed to diarize the appeal and list the matter for admission after 2 weeks. Petition disposed of. For two weeks?
Lordship, just a small confusion, my lord, if my friend could kindly help us. Lordship, at page 8, the date of admission is 24th of April 2024 and the date of discharge is 19th of June 2025. Whereas at page 9, the last visit date was 25 April 2025 with a token, Lordship. That means OPD. So there's a bit of confusion because it appears that he was admitted for a period of more than 1 year at page 8. But here he's an OPD within that period of 1 year, more than 1 year, Lordship.
This is a typographical error from Mimhan's, Lordship. I've made an averment in paragraph 4, page number 3. We've made a typographical error. I've clearly stated that there's been an erroneous recorded in a summary. It should have been 24/4/2025.
Okay.
Yes, Lordship, from Mimhan's. Paragraph 4, the fourth last line, Lordship.
It was
erroneously recorded as 25/4/2024 instead of 25/4/2025.
Okay.
Yes, Lordship.
We will ignore that. Okay.
Obliged, Lordship.
Much obliged, Lordship.
Daily list item number 1.